Next, we've got Jones Stutman, file 23-6718 FH for sentencing. We also have a pending contempt matter, but that matter hasn't been resolved in Chippewa County, has it?
Not to my knowledge.
No.
Okay, I think it's probably best if we dismiss that contempt and defer to Chippewa County.
I thought she played no contest.
She pled no contest.
Yeah.
To the violation?
Yeah, at the time of the plea.
Oh, okay, all right. Oh, she did, I see that, okay. All right. All right, Mr. Gilbert, have you had a chance to review the report and recommendations?
Yes, we have gone through the report and the recommendations, and there are no additions or corrections.
And the advisory guidelines are 0 to 6, any scoring challenges?
No scoring challenges, Your Honor.
Ms. Goodrich, any additions, corrections, or scoring challenges?
No, Your Honor.
All right, Mr. Gilbert, go ahead.
One of the major things that I know my client would like to get from today is she can start after the sentencing to have contact with her mother. This has been her mother is involved in this case. I know this has been something from the beginning that's been very painful for her. Considering the low concern my client has had until this point in her life, no issues whatsoever, no misdemeanors, no felonies. I'd ask the court to take that in consideration. We believe the period of probation is appropriate, and we'd ask that the court sentence her to time served and the rest of the recommendations as prescribed in the PSI.
All right, thank you. Ms. Stutman, you don't have to tell me anything today. But it's allowed. Is there anything that you want to tell me? Or no?
Not that I'm aware of.
Thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. I'm in agreement with the recommendations in the PSI. The defendant is 67 years old with no prior criminal history. At the time that she was appointed full conservator, she was using her mother's money for her own purposes, and while having her mom pay for the defendant's apartment, her own mother was living in a house that had a leaky roof that had no running water except for in the kitchen sink. Her mom was suffering from dementia and didn't have anybody overseeing whether she was taking her medicine or taking care of herself or eating or having proper food and provisions in the home. It was such horrible conditions that the newly appointed conservator never took her back to that home once she was court appointed, and took her to a home where now she's being properly taken care of and in a memory unit, receiving proper care. Even despite this case pending and everything that happened, the newly appointed conservator was constantly asked by the defendant for additional monies of her mother, and just didn't seem to understand that that was not an option. And so on page 2 of the CFJ 284, where it talks about the self-report criminal thinking scale, that she really can't rationalize her criminal behavior, I thought that that was appropriate. Working on this case, that she just doesn't understand the error of her conduct, which is concerning. Ask the court to take all that into consideration.
All right, thank you. All right, Ms. Stutzman, while you're 67 years old, you have no prior record, but this is a case that the more I learned about it, the more I was troubled by your conduct, that you not only violated the trust,
I'm not told anything about any difference what I was supposed to do or act with the trust. So I just kept doing what we were doing. That's the way my mom and I's always lived. While I was in Petoskey, she always paid my rent. She's always helped me with this, that, and the other thing. So I just kept doing what we were doing.
well, you pled guilty.
Just to get it over with. I was
You want to withdraw
innocent.
your plea? I'll let you withdraw your plea and we'll set it for trial.
He said I wouldn't win, so
Well, it's not up to him. He advises you.
whatever to get out. That's all I want. I want to go home and
Yes.
see my mom.
All right, you've pled guilty. That's part of the problem is you know
We were
you
close.
pled guilty but think you didn't do anything wrong, but you did. You violated the trust of your mom. You violated the trust of the probate court that appointed you a conservator all to kind of help out your son who's in prison, stealing from your elderly mom to help out your son in prison. And then while you're on bond, you're smuggling drugs into a prison, again, for your son and for your own financial benefit. That's really pretty troubling conduct, and you completely think that we're all wrong about that. Well, I'm telling you, we're not wrong. You take a poll of people in the community. Should you take money from your mom and give it to your son in prison? Should you smuggle drugs into prison? I guarantee you about 100% of people are going to say, no, you shouldn't do those things. You did those things, Ms. Stutman. And so I gave you an opportunity to speak. So now is the time for the sentence to be imposed. I don't think, so obviously there's restitution that's ordered, agreed upon at $55,371. There's a crime victims assessment of $130. You have to comply with DNA testing and pay a $60 fee, and there's $68 in state costs. I'm not going to assess court costs. I don't think you're going to pay a penny of that.
I will.
Yeah, I don't know. I don't think you will. And I certainly don't think that placing you on probation accomplishes anything. She's got no understanding of her criminal behavior, and she's on Social Security disability. I mean, probation to help oversee payment of $55,000 is not going to accomplish a thing.
And I just have it automatically taken out of my account.
Ms. Stutman, I gave you a chance to talk.
I didn't know we were going this direction.
Now we're done with it.
I gotta respond to what I hear.
We're done with that. So, given the issues on bond and the sheer amount embezzled, I think even though it's 0 to 6 calls for no incarceration, I do think there is reasonable grounds for incarceration. So I'm not going to place you on probation. I'm going to order you to serve 6 months in the Sheboygan County Jail, get a credit for 78 days previously served. On the contempt, I'm going to order you to serve 77 days, credit for 77. That's the sentence of the court. If you wish to appeal, you can file an application to the Court of Appeals. If you want a lawyer, let me know. I'll appoint one for you, but you got to ask within 42 days. There's, now that you're sentenced, there is not any limitation on your contact. It will have to be through phone visits or whatever from the jail. All right, that's the sentence of the court.